it would cost 3 times the amount to ship water from Tennessee to Las Vegas. Specifically per truckload, a difference of $3,600 to $1,200. It's facetious that he's making these arguments.
All right.
All right, good afternoon. Now let's go ahead and set forth our appearances for the record.
Will Kemp and Teddy Clark. Good afternoon, Your Honor. Joel Odou, back from
Good
Afternoon, Your Honor. James Neale, John Anderson, and Mr. Davis Burlock on behalf of UNFI.
Good afternoon, Your Honor. Scott Rasmus on behalf of Henderson's Inc.
Afternoon, Your Honor. James Cavanaugh and Robert Schumacher here for Real Water Tennessee, LLC.
Good afternoon, Your Honor. Rob Robbins and Elizabeth Lowell for Milwaukee.
All right. And I think that covered all appearances, correct? So next up, is that Mr. Cavanaugh's motion?
Well, it is now, Your Honor.
Yes, that's what I thought.
I just wanted to
That's what I
know
hear.
that I provided the defense counsel with a copy of the bullet points for Dr. Goldman.
Smith.
Yes.
Goldsmith. Yeah, Goldsmith. And I gave an extra one to Mr. Rasmus and Mr. Robbins. I don't think they had a chance to look at it, so I just wanted to report the order that I did give it to them.
And we can maybe talk about it later. Yes. Sir.
Afternoon again, Your Honor. Jim Cavanaugh from Real Water Tennessee, LLC, third-party defendant. And we're first starting with Real Water Tennessee's motion for summary judgment regarding United Natural Foods West defendant, third-party plaintiff complaint for indemnity and contribution against our client. As I think Your Honor is aware at this time, our client was an Tennessee located bottler and supplier of the Real Water product. And prior to Real Water of Tennessee's undertaking in that regard, which began by a contract in 2010 with Real Water Inc. and Affinity Lifestyles, the Nevada-based companies. Real Water defendants, Real Water Inc. and AffinityLifestyles.com, had been doing business with United Natural Foods Inc. And United Natural Foods West, apparently, for some time, since 2008, years before Tennessee began distributing water on the western United States. Our motion has attached to it the agreement that is at issue with United Natural Foods Inc. It's a food product supplier agreement dated December 5th, 2012. And if you do the math, that's almost 5 full years after United Natural Foods was already doing business with Real Water Inc. and Affinity Lifestyles, and they were doing business out here in the Nevada market. The contract that Real Water Tennessee entered into with Real Water Inc. and AffinityLifestyles.com was for an exclusive bottling territory encompassing 9 eastern states, including Tennessee, South Carolina, Georgia, Alabama, North Carolina, I believe, and a couple of other eastern located states. They were excluded from selling product or to the Nevada-California market by contract. When they entered into an agreement 5 years later with UNFI, UNFI is not a defendant in this case. UNFI was also not sued. But when they entered that agreement, it was, it's Exhibit A to the motion.
Yes.
You just look at the first page, Your Honor, and it's fairly simple, straightforward. Look at paragraph 3. Subject of this agreement is the, in quotes, products from the facilities, in quotes as well, of Real Water of Tennessee. To skip ahead, the court is probably now aware that there hasn't been much discussion about Real Water of Tennessee's products, and that's because plaintiff has not sued Real Water of Tennessee. And there's been no competent evidence that any Real Water of Tennessee products from Real Water of Tennessee's facilities is involved at all in this lawsuit. In fact, in plaintiff's motion eliminating number 41, they essentially asked the court to bifurcate out the indemnity claims between United Natural Foods West and Real Water of Tennessee because, as they say, and as they know, and have better reason to know than anybody, none of the Real Water from Tennessee product was consumed by the plaintiffs in this case. So to skip ahead to the reason we're here, we've completed discovery. Natural Foods has produced no documents that tie Real Water of Tennessee's products to its purchase and sale to Whole Foods, and no products from Real Water of Tennessee were ever distributed to Whole Foods in Nevada, and therefore no Real Water of Tennessee product from its facilities or in any way responsible for the alleged injuries and damages the plaintiffs have suffered. In order for United Natural Foods West, which wasn't actually the signatory to this contract on which they sued for contractual indemnity, they must show that products from the facilities of Tennessee were involved in the injuries for which they are responsible to plaintiffs. They can't do it. There's no genuine issue there. There's no genuine dispute. They have no documents to tie that together. They want to point to, as it comes up in other motions eliminated, they want to point to a bankruptcy status. All of the Real Water entities went into bankruptcy following the recall, the FDA cease and desist, and all of them went out of business. Eastern U.S., Western, it was all shut down. Prior to that happening, I should tell the court, if it's not evident from the pleadings, Real Water of Tennessee's ownership was purchased by Real Water Inc. and by Affinity Lifestyles in March of 2019. However, there's no disputed evidence of it. Otherwise, the president, Britt Jones, testified in his bankruptcy 341 creditors meeting and also endorsed the same opinions in his deposition June 8th of this year. The Real Water of Tennessee continued operating out of Tennessee until December 2020 or January 2021. So as the court is now more than aware, the two plaintiffs that are suing United Natural Foods, their injuries occurred in 2018 and in 2019. There's no evidence to dispute, no genuine dispute, that the Real Water of Tennessee product was still coming from its bottler in Pall Mall, Tennessee, at the earliest until December 2020. And as far as the bankruptcy consolidation, we have a motion in limine to be heard a little bit later, Your Honor. The trustee, for the convenience of administering the estates, because Tennessee was wholly owned by the real water entities at that point, there were limited assets. They consolidated them and administered the estates at that time that way. You know, the argument, maybe, maybe not, is that somehow that consolidation in December of 2021 in a bankruptcy proceeding had somehow subsumed acts and production of Tennessee that occurred many years earlier. It just makes no sense that they would argue that, but I think that's part of their rationale for believing Tennessee has some liability to them. Some very good attorneys in this room, and behind me are some really good attorneys. They didn't sue Real Water of Tennessee for a reason. They didn't even sue United Natural Foods, Inc. for a reason. And it's very evident when you review the documents, you review the lack of any discovery that brings a genuine dispute into this, that Real Water of Tennessee should be is legally entitled to summary judgment on these facts and the law. Does the court have any questions that I could answer?
Not at this time, sir.
Thank you, Your Honor.
Sir.
Thank you, Your Honor. Jim Neale for UNFW. Your Honor, we're here in a familiar procedural posture to the court, and I'll, just to remind myself, not the court, I'll say out loud that any genuine issue of material fact precludes the granting of this motion, and that all inferences have to be construed in the favor of the non-moving party. I know the court's aware of that. Mr. Cavanaugh just told the court 4 things that I think he portrayed as uncontested facts when, in fact, there is competent admissions by Tennessee that they just simply aren't accurate. Number 1 is that the entity was Tennessee located. After March 1, 2019, it absolutely was not. Number 2 is that the facility operated exclusively out of Pall Mall, Tennessee, until late 2020 or early 2021. That is not correct, Your Honor. I'll show you the evidence of that momentarily. Number 3 is that the water had to come from Tennessee to here in order to be distributed to the plaintiffs. That's not the case. I'll show you admissions from the president of Real Water, Inc., which was the sole managing member of Real Water of Tennessee, that Tennessee was manufacturing and bottling water out of all Real Water facilities in 2019 and thereafter. Mr. Cavanaugh, in his motions, Your Honor, is very fastidious about observing corporate formalities between and among the Real Water entities. Unfortunately, Real Water of Tennessee, his client, was not in any comparable way. After Real Water, Mr. Odou's client, Real Water Inc., purchased the remaining interests of Real Water of Tennessee, they were consolidated here in Las Vegas. They were run as one entity. There was no distinction made between or among those entities. We have admissions from Real Water Inc.'s president to that effect. They declared bankruptcy together. The reasons for it, if Mr. Cavanaugh was correct and Real Water of Tennessee never was involved in the distribution of water here, the reasons for the bankruptcy would hardly be apparent. They did it, of course, on the same day with the same counsel as the other Real Water entities because they were one enterprise. Mr. Cavanaugh referred briefly, Your Honor, to the bankruptcy order. And I believe he said that was entered for the convenience of the administration by the trustee. That's not the case. That order was entered because of the hopeless entanglement among the debtors, Real Water Inc., Real Water Tennessee LLC, and Affinity Lifestyles, including the commingling of funds, which Mr. Jones admitted to during the 341 hearing, and the trustee, the United States trustee, who is a fiduciary for the claimants in this room, including the plaintiffs and the cross claimants and the third party claimants, admitted on the record in support of that motion, which the bankruptcy court granted without opposition. So just to review the history, Your Honor, everything that Mr. Cavanaugh said about Tennessee being different and separate is correct before March 1, 2019. And on March 1, 2019, John, can you pull up the membership redemption agreement, please? On March 1, 2019, Brent Jones bought the remaining shares of Real Water of Tennessee. It was previously a separate LLC, like many other licensed distributors around the country, operating independently in Tennessee, according to the terms Mr. Cavanaugh described. But Brett Jones bought the remaining interest, Your Honor, March 1, 2019, uprooted the company, physically moved everything to Las Vegas, and then ran it out of the same facilities as were Real Water Inc., Real Water Gold Coast, Affinity Lifestyles, etc. March 1, 2019, Your Honor, it becomes part of the Real Water family. It becomes part, Your Honor, of the combined enterprise. John, can you pull up, please, Exhibit D, Mr. Jones' deposition at page 147. Lines 15 to 21, please. This is the deposition, Your Honor, of Mr. Brett Jones, the president of Real Water Inc., which is the sole member of Real Water Tennessee LLC after March 1, 2019. Did you consider it to be a single economic unit? I would consider that we were in the process of consolidating them. They were run as one consolidated entity thereafter. All right. Your Honor, you were told that Real Water Tennessee and Real Water were separate companies. John, can you pull up page 113, line 12, and page 114 also? Just put them side by side if you would. I want to call the court's attention to Mr. Jones' testimony. He's asked at page 113, line 12, before we took a break, you referred to Real Water Las Vegas. What is that? What do you mean when you refer to Real Water Las Vegas, sir? He answers, well, it depends on the time period, but Real Water Las Vegas generally was referring to the 3208 West Desert Inn address. That's the Desert Inn facility. That's where our main operations occurred for the majority of the company's life. It's not an entity. Here's Mr. Jones' answer. No, it's Real Water. But they're all Real Water. Like Real Water Tennessee is Real Water Tennessee, Gold Coast. So when we refer to it, like we refer to Gold Coast or Las Vegas or Tennessee, because they're all Real Water. Judge Williams, there were simply no distinctions made between the companies by the president of the company. You were told that they had completely separate facilities. Page 97, please, John. Line 23. CJR, Your Honor, is the co-packer in Pall Mall, Tennessee. The question of Mr. Jones was, did all of Real Water Tennessee's product get produced by CJR? His answer is, when they were operating out of Tennessee, yes. Can we go to the next page, please, John? Question, what about after that? I'm not certain. Right, after that, some of Real Water of Tennessee's product was produced and bottled in the Real Water Inc.'s facilities. Objections, isn't that correct, sir? I'm not certain. You believe it might have been. It could have happened, yes. There were simply no distinctions between the companies or the place of production at that point. Page 102, please, John. line 8 through 20. What you said before all of the objections was that after March 1, 2019, when you acquired the remaining interest in Real Water of Tennessee, are you with me? Yeah. You said prior to that, all of the Real Water of Tennessee was manufactured at CJR, correct? Correct. And after that, you acknowledged that some of it may have been manufactured in the Real Water Inc. facilities, either at Desert Inn or at Mesa, Arizona, where that moved after that. That alone is sufficient to create a genuine issue of material fact. You were told that the entity serves separate geographic areas, page 92, please, John. 9220 to 935. This is Mr. Jones explaining a purchase order that showed water being shipped from Tennessee to California for distribution. Do you know whether Real Water of Tennessee shipped product to the West Coast? I was not aware of it. Do you think it may have occurred? I think that transcription there is correct. If nothing educational on occasion, I think that's an error. It could have absolutely occurred based on these documents you're showing me, Judge. This is Real Water Inc.'s president admitting that Real Water of Tennessee distributed product on the West Coast, contrary to everything Mr. Cavanaugh just said. Page 101, please, John, and 102 if you could at the same time. Starting at line 8 on page 101, the documents you just looked at earlier suggested to you that distributing the product on the West Coast happened on at least one occasion. It may have happened, yes. Keep going there, John, please. We go to the next page, please, John. What you said before about before all of the objections, before March 1, 2019, when you acquired the remaining interests, again, Your Honor, he said some of the water, Real Water of Tennessee, may have been manufactured at Real Water Inc. facilities here in Desert Inn, Your Honor, or in Mesa, Arizona. All right, Your Honor, I'm going to skip ahead. I think those facts they show that there's genuine issues of material fact here. Real Water of Tennessee product was made in several facilities. It was distributed on the West Coast. But let me show you, Your Honor, very briefly, if I can, some facts about Real Water of Tennessee being the same entity that Real Water Inc. is. And I'm sorry, Your Honor, if we need to take a break, I hope you'll let me know. Your Honor, Real Water of Tennessee, after it was purchased, had no employees, no property, no assets. It produced the same product on the same equipment. Its liabilities were paid out of Real Water Inc.'s bank account. It was simply swallowed up into the Real Water Inc. entity. Now, it's fine for a company to provide services for an affiliate, but when it does that, there has to be some arm's length transaction. If Real Water Tennessee is going to move in with Real Water Inc., there ought to be a lease. If its employees are going to provide services, there ought to be a services agreement. There was none of that, Your Honor. It just simply got absorbed. So it had no independent revenue and no independent obligations. Real Water Inc. collected and paid for those. John, if we could go please to Mr. Jones' deposition at page 129 and 130. This is Mr. Jones, the president of Real Water Inc., saying, I don't know what accounts liabilities of Real Water of Tennessee were paid out. When we get to the 341 that Mr. Cavanaugh referred to in bankruptcy, you'll see his admission that Real Water Inc. paid everything. So what we have, Your Honor, is the two companies in one place, in one facility, making the same product, operating as one unit, in one bottling company with the same employees on the same machinery. In fact, Your Honor, when Real Water of Tennessee moved after the purchase, It simply surrendered its assets to Real Water Inc. No written agreement, no money, no consideration, no nothing. It just essentially, again, got swallowed up. All right, I want to talk briefly, Your Honor, and then I'll sit down, but I want to talk briefly about the bankruptcy order. To reiterate, Real Water of Tennessee declared bankruptcy with Real Water Inc. and Affinity Lifestyle. Same day, same counsel, same pattern. Mr. Jones, the president of Real Water Inc., was the debtor's spokesperson at the 341 meeting, the meeting of creditors. John, can you pull up Exhibit I to the motion, please? Page 10 and 11. The 341 meeting, Your Honor, is where the trustee, you may be familiar with it, forgive me if I'm telling you something you know.
But make a record, that's fine.
The 341 meeting is where the trustee, again, the fiduciary for the assets of the debtors, asks the debtor questions under oath. Line 17, John, to page 11, line 5, please. The trustee asks, when you say we, which company was doing this, or were they all kind of doing it together? Mr. Jones' answer under oath to the trustee is, yeah, the breakdown was Affinity used to be the operating company. And then Real Water was set up underneath it, and Affinity was a holding company. And then Real Water of Tennessee, we had another partnership with the LLC, with another entity a few years ago. We bought that. Page 11, please, John, up to line 5. We bought that partnership out about 2.5 years ago, so they were all working together. Yes, doing the same thing. Real Water was the main operating company. Real Water Tennessee was kind of absorbed into Real Water. It was more than kind of absorbed, Your Honor. It was swallowed whole. And thereafter, everything that Tennessee did was part of Real Water, and everything that Real Water did was part of Tennessee.
And they didn't have any formal agreements or anything like that?
Zero, Your Honor. No leases, no services agreements, nothing.
No operating?
No operating agreement, nothing. It gets worse. Page 13, lines 2 through 17, please, John. The trustee asks Mr. Jones, how were the bills paid? What about vendors? When vendors needed to be paid, or needed paid, who did they submit their request to? To the Real Water. Okay? To Real Water. Particularly the ready-to-drink vendors, that's what we've referred to as the retail. They would have gone to the 601A, I think that's the Mesa, Arizona address. The 5-gallon would have gone to the Henderson location. So the bills are sent in 2 different directions. UNFI is always dealing with Real Water of Tennessee, but then look what happens. But would it have all been paid from, say, Real Water Incorporated's account? Yes. Okay, yes. Real Water Incorporated is paying everything for Real Water of Tennessee after the merger. So that's why, Your Honor, in the bankruptcy court, the trustee went to the court, Exhibit J to the motion, please, John, page 6. The second line, in fact, is the last paragraph. And said, Your Honor, to the bankruptcy court judge, we've got to put these 3 separate debtors together because that's the way they were operating. And this is his motion. He says the consent decree alone tends to establish that the debtor's affairs are entangled to such a degree that the government of the United States found it necessary to enjoin all of the debtors from conducting business. If Real Water Tennessee were separate, that would have been completely unnecessary. Additionally, the overlapping litigation, the identical operators, employees, officers, etc., tends to suggest that the debtors were entangled to such an extent that consolidation is appropriate. Further, per Real Water of Tennessee's schedules, bankruptcy schedules, it previously assigned its remaining assets to Real Water, which is further indication of entanglement, warranting consolidation. To reiterate, it got to Las Vegas and it then just turned its pockets inside out and said, take what you want to Real Water Inc. And because Real Water Inc. was run by Mr. Jones, he said, thank you very much, I'll help myself. He took everything there was, no payment, no consideration, no agreement, no nothing. And then it says, Your Honor, Mr. Jones also testified at the debtor's 341A meeting of creditors that vendors would submit payment requests to Real Water, and all payments on behalf of the debtors would be made from the corporate account of Real Water. The funds are completely commingled. They're operating as one unit. They are hopelessly entangled. They have the same operations, management, facilities, assets, and liabilities. And that's exactly what Exhibit H, please, John, the trustee's affidavit. That's exactly what the trustee, again, a fiduciary for all of the creditors in this room, told the bankruptcy court when he filed his declaration in support of that motion for substantive consolidation. And then, Your Honor, this is what the bankruptcy court did with that. And I want to point out before we get here, Real Water of Tennessee didn't stand up and say, oh, no, we're separate. Don't lump us in with them. We observe corporate formalities. They did nothing. They sought the protection of the bankruptcy court together. They stayed in the bankruptcy court together, and they didn't oppose the motion for substantive consolidation. Now, what's that mean? Exhibit A, please, John, consolidation order.
I mean, I would think that would mean potentially judicial estoppel would apply.
Well, I think judicial estoppel definitely applies, Your Honor, but there's a practical, substantive. Not only can he not now come in and say something different, but there's a practical, substantive implication here. At the bottom of page 2 and top of page 3, Mr. Stevens is going to show us what the judge did with that. So it is hereby ordered that the motion is granted in its entirety. The court has to deny the motion. At an absolute minimum, there are genuine issues of material fact. I think the motion's been decided by the bankruptcy order, and the judicial estoppel applies. Question, sir?
Yeah.
Thank you.
Sir.
Your Honor, Robert Schumacher, Mr. Cavanaugh has some comments, but if it pleases the court, depending on what is said, I'd like to have a few words afterwards.
Oh, yes, sir.
Thank you.
Thank you.
Mr. Cavanaugh, sir.
Your Honor, I'm pretty disappointed. Counsel emailed me last night to see if I had a copy of my reply that I could share with him because he didn't have it. I had a computer issue and I gave him the date it was filed. That reply brief, Your Honor, would rebut virtually everything that you just heard here, and in detail with citations to actual testimony, actual documentation. I didn't count them, but you just heard the words could have, may have been, could have multiple times, kind of. But I'm disappointed because the way this is being characterized, it's as though I wasn't in the same deposition. Although I do understand how skillfully counsel attempted over and over again to get Mr. Jones to say, Mr. Jones, a president of multiple companies who was not running the day-to-day operations and had no firsthand knowledge of what the procedures and policies were. But he clearly over and over again said the company was being operated out of Tennessee up until, to the best of his knowledge, December 2020, January 2021. All of these dates, certainly well after, including this bankruptcy discussion. Mr. Neale wants to live in the bankruptcy court, Your Honor. He doesn't want to be here in the state court. And that's evident by his multiple attempts to remove the cases. He thinks his best shot is apparently this consolidation order that happened without a hearing,
to companies that were in bankruptcy with no assets, not even,
Is that the order? I just want to make sure I have it because I was looking for it. That's the order dated October 15th, 2021?
it sounds like the right date, Your Honor. I don't have that in front of me.
Your Honor, it's Exhibit A to our opposition, and it is dated December 2nd, 2021, I believe, Your Honor.
Yeah, I guess what I was looking at the trustee's affidavit.
Yes, sir.
That's where I got that from. And here's my question, and that's why I really, after listening, and I understand we can have issues of fact regarding specific legal issues that could preclude summary judgment. But what do I do? And this is something that happens from time to time when I get orders from bankruptcy courts, and not specifically regarding, the debtors and creditors' rights and those types of things, but specifically focusing on positions taken in a bankruptcy court. And once a bankruptcy judge makes a determination based upon those positions taken, and sometimes I'll see it in this respect. I've had cases where, for example, a debtor might make a claim that they don't own certain property. And then they come down to district court, and now they're making a claim that they own that property. And there's a lot of case law out there that deals with that being an issue regarding judicial estoppel, right? Because you can't take a position in bankruptcy court and then take and the bankruptcy judge adjudicates it and relies upon that decision, and then come to state court and take an adverse position.
Can't approbate and reprobate.
Yeah, right. And the only reason I brought that up is I was listening, and then once we got to the consolidation issue, that just kind of jumped off the page as a trial judge. And my point is, if the bankruptcy court has ruled that there was consolidation of the entities, and they're one for all practical purposes, okay, that has to have some force and effect. And see, I can't sit back and say, well, the bankruptcy court, that's just what they think. No. If there was some sort of issue regarding that ultimate decision by the bankruptcy judge, that should be appealed, right? And so what do I do under those circumstances? Because I want to make sure I can see that. I know it's Exhibit A. There's a lot here.
Well, Your Honor, may I
Absolutely
speak while you're looking for that?
It is right.
What a trustee move for without opposition or a hearing to consolidate for the convenience of the creditors in a proceeding that happens several years after the facts at issue in this case. It didn't take into account any of the facts that are before this court about the plaintiff's injuries. And to back up a step more, Mr. Neale's client stipulated, drafted the order to lift the stay to proceed against the Real Water of Tennessee entity separately, because it is a separate entity. I heard so many misrepresentations of the facts, and that's why I hope Your Honor has had a chance to review the reply, which addressed a lot of this.
Yeah.
There were separate checking accounts. It's an asset in the bankruptcy petition of Real Water of Tennessee. I heard so many inaccuracies here, Your Honor. But Mr. Neale wants to live in bankruptcy, and he has Your Honor now looking up bankruptcy law.
No, I'm
not.
I'm not looking at bankruptcy law. I'm not doing that. Ultimately, if a bankruptcy court makes specific findings, I can't ignore that.
Judge, there's something on the screen that's.
It looks like Mr. Robbins is walking around somewhere.
Oh, is that UNLV?
Okay, there we go. Okay.
Stop snooping on me.
You don't have a tie on.
Turn your camera there.
Yeah, you're FaceTiming everyone, Rob.
Your Honor, can I just continue?
Oh, absolutely.
You heard
We've
that
taken
bills
care-
are being sent to two. So Real Water, picture this, Your Honor. Here's a facility called a co-packer. They're actually a manufacturer of the product paid by Real Water of Tennessee to bottle and help them distribute the Real Water of Tennessee product to the 9 eastern states. And if there were any documentation that it was going otherwise, instead of making up testimony of the trustee to throw before you, Mr. Neale would have shown you receipts, would have shown you bills of lading that involve Tennessee water coming to Nevada. They don't exist. And so his only hope is to make up this combined assets argument that the wholly owned subsidiary, the tail is consuming the dog and dictating what's happened here. All this could have happened. He got Mr. Jones, who was the president of several companies, more than several, to try to get him to agree that the operations happened in Las Vegas. Every time he tried to ask that question, Your Honor, Jones said, no, it didn't. I don't know how many times you can ask that question. He took complete dispute with it. Your Honor, the biggest cost in the water business, think about it. What might that be? It's shipping, Your Honor. It would cost 3 times the amount to ship water from Tennessee to Las Vegas, specifically per truckload, a difference of $3,600 to $1,200. It's facetious that he's making these arguments that it's run out of Las Vegas. It was never run out of Las Vegas. And if you read their discovery responses, their trucks are pulling up to Desert Inn. Their trucks are pulling up to Mesa, Arizona, and taking the water from the entities that are now being sued. That water never came from Tennessee. And this idea that bankruptcy somehow consolidates and mixes assets, that somehow that reflects on something that happened 3 years earlier or 4 years earlier. Mr. Belsky was in and out of the hospital, suffered all his damages that are the subject of this lawsuit, and was recovered in 2018, which was a year before this final purchase by Real Water of Inc. I hope Your Honor recalls that. So the 2 plaintiffs that are suing United Natural Foods include Haley and Belsky. Belsky, it's an impossibility that he could have been injured, even if you want to call this administrative entanglement some basis for the injury. Your Honor was in some Kitech cases. I think Vanguard Viega may have been one of them. Vanguard GmbH.
There were quite a few.
Yeah, remember Vanguard GmbH?
I think I had them all. But...
Yeah, do you remember Vanguard USA made some of the fittings for these Kitech plumbing companies? Remember Vanguard GmbH, the German corporation, got dismissed because they couldn't prove there was an agency relationship between the parent, which Vanguard GmbH was in Germany, but it didn't have an agency dictating what the lower entities did. And this idea that everything's entangled, he never pled alter ego, Your Honor. This is something made up on the fly. He didn't give us any notice pursuant to Rule 8. And he's really just made up testimony here. This idea there's no assets, how do you think, why can't he produce one check, one canceled check for an order that had Tennessee's name on it related to this case? He says the invoices and bills are going in 2 directions. Oh, are they really? Well, where are those documents, Mr. Neale? There are no such documents. You just make up things. It harkens back to this idea of manufacturing sales data for your prior, for which you were sanctioned already. I mean, to stand up here and tell Your Honor all this baloney is just mind-blowing to me, Your Honor. I got to tell you, I'm very disappointed. And if you look at the reply, you'll see it.
Well, no, I have that. I'm just what I'm trying to do is this. I'm looking at the order, trying to interpret specifically what the order granting motion for substantive consolidation non-protunct as of the petition date pursuant to 11 USC section 105A. And as far as what were the petition dates? I might have overlooked that.
August 19, 2021.
That was a bankruptcy petition?
Yes, sir.
Okay. All right. So, if that's the case then, and looking at it through that lens,
It's well after all the injuries that are at issue.
Well, that's my question.
Well after.
Okay.
Years after. In fact, Belsky and Mr. Haley, which are the subject of the indemnity he now seeks from somebody who had no product. Nothing came out of the operations. No products, quote, Exhibit A, paragraph 3, it's about the products, in quote, coming out of the facilities, in quote. He has no other right contractually to any indemnity that doesn't come out of those operations. And this idea he can run to this bankruptcy consolidation order and have that justify a claim for indemnity against an innocent third party is reprehensible. It violates Rule 11, probably. I mean, this is just
One thing we've tried to do is keep above the fray. We don't have to, right? We don't have to do that. But I just want to make sure I understand this because I do respect bankruptcy courts. I do. I try to make sure that when, for example, if there's filings, I understand what happens and the impact of the automatic stay. I understand the specific section as it pertains to seeking relief from the automatic stay, proceeding against insurance proceeds. But I was just I had one question, and I look at the order granting the motion for consolidation, nunc pro tunc, by the petitioner that was filed, I guess, on, and I wanted to make sure I have that because it appears to me that unless I'm incorrect in this, and looking at the order, it says consolidated debtor and their estate shall be subsequently consolidated nunc pro tunc as of August 19, 2021. So practically speaking, the order might not have any impact at all on this case. But that's all I was trying to clarify because I want to make sure I understand the facts. So there's no reason that we can you understand what I'm saying?
Your Honor, people who have studied all these issues much better, I think, than Mr. Neale would have sued our pants off if we had culpability here for these issues. And they didn't, and in fact, their motion 41 is to get us out of their way. They didn't consume our water. And all this other stuff is subterfuge, Your Honor. And all the could have, would have, maybe, could have happened, may have occurred. I hope Your Honor was paying attention to all that may have been, because he has not one document that shows that it was, despite the fact he's representing they just turned over the assets. Oh, did they really? Well, the petition doesn't show that. They have a separate banking account. And who in the world paid CJR Bottling for the next 2 years, 3 years after the purchase on March 2019? Who paid them? Show us one check that you claim was paid. And if it was, what does that have to do with the liability issues for which Mr. Neale's client's being sued for in relation to an indemnification obligation of Rural Water of Tennessee? It doesn't connect. There's no causal relationship here at all, Your Honor. All the could haves, would haves, he has to come up with one document. And he said that in his written discovery responses, Your Honor, but he tried to load it up with a lot of qualifications and go, oh, look, bankruptcy, this isn't relevant for you to ask me if you have any documents to support your indemnity claim. Bankruptcy. It's Your Honor, you have jurisdiction here.
No. I'm not saying I don't have jurisdiction. I was just trying to query what was the impact of the bankruptcy order. Nothing more, nothing less. And it appears to me it might be cleared up now. That's why I asked the questions I asked. That's all. But continue on, sir.
Well, there's a huge void here. It's called documentation, it's called evidence, it's called proof. And cherry picking some sort of in-between lines that said, well, it could have happened. Yeah, it could have happened. But he also says in the next line, I would have been really pissed because it cost 3 times the money to send the water across country. He never admitted to there was a consolidated operations of these. And again, Your Honor, very good attorneys right behind me would have already sued our pants off if that was the case. You can rest assured of that. This hopeless entanglement, it's just invented. It's invented that they just surrendered. Where's the documentation that they just surrendered anything? There's no proof of that. Now's the time to come. Discovery's over. You've come forward with nothing on behalf of United Natural Foods. Nothing. Nothing. Not one piece of paper. You've made up stuff.
Mr. Cavanaugh, we don't have to go after each other. I mean, it is a important case, and we try to keep above the fray. I just had a question regarding the potential impact of the bankruptcy order.
I respect Mr. Neale. I'm very disappointed. He came up here and misrepresented the records, misrepresented things that weren't so. It doesn't have a piece of paper to even show the court to back up these representations. And he thinks, that's all I need, Your Honor. I've created it's not a genuine dispute when somebody just makes up his own version of the facts. That's not a genuine material fact dispute, Your Honor. And I apologize for getting more excited about this than I would have been. I would ask, Your Honor, if you have a question, you let me try to answer it. And if not, maybe Mr. Schumacher, if you would allow him, has maybe a comment. I'm not sure.
I understand, sir. And thank you. Sir.
Thank you, Your Honor. I promise to remain above or outside the fray. My comments will be brief.
Yes, sir.
I think there's a legal basis for the court to grant this motion. And it really, you look at two documents. The first is motion to eliminate 41 filed by the plaintiffs. And I'm going to quote from it at page 2, lines 17 through 20, or 17 through 19. Plaintiffs have filed suit against the real water entity that made real water at the Desert Inn and Henderson plants. Plants have not sued, or plaintiffs rather, Tennessee, because it did not supply the water that they consumed. That's a judicial admission. I'm confident that Mr. Parker, Mr. Kemp will confirm that that is the position they've taken in this case and will take when they present their case in chief on beginning on September 5. The next document is Exhibit A to Real Water of Tennessee's motion for summary judgment. And,
let me find it for you, sir, because I want to follow you.
Sure.
All right. I know I have that, but go ahead.
Okay.
I want to make sure.
Yeah, Exhibit A is the, make sure I get the title right, the food product supplier agreement. And if we,
and I have it. What page are you on again, sir?
well, I was reading the title of the document first.
Okay.
And then I think if we go to page 4 of the document, specifically section 13 entitled Indemnification Insurance, and then go to 13B, which is defense by supplier. Supplier is Tennessee. And I'll read, quote, supplier will defend UNFI, its affiliates and subsidiaries, their officers, directors, employees and agents, as well as any customers of UNFI and its subsidiaries against any allegations asserted by any third party or damages sought any claim by a third party alleging any of the following. Now, third party in this context, within the context of this indemnification provision in Exhibit A, the Food Products Supplier Agreement, is actually the claim presented by the plaintiffs. They're not third-party plaintiffs, but they're a third party to the agreement between Tennessee and UNFI. So we look at the third-party claim, the plaintiffs' claims in this lawsuit, to see whether plaintiffs have alleged any of the following. Number one obviously doesn't apply because it pertains to copyright and other IP rights. But Section 13B2 does. And it states, quote, death of or injury to any person, damage to any property, or any other damage or loss resulting in whole or in part from any quality or other defect in the product. The product is initial capitalized, so it's a defined term. We'll get to that in a minute. Whether latent or patent or failure of the product to comply with any express or implied warranties or any claim or of strict liability in tort relating to the product. Now, what's the product? What's the definition within this agreement between the parties? Let's go to page 1 of Exhibit A, Food Product Supplier Agreement, and it defines products in paragraph 3. Now, quote, UNFI will purchase from supplier, which also is a defined term in the agreement between the parties, and distribute to customers certain food products made by supplier at its production facilities. So we have 3 defined terms within paragraph 3. Products is defined, and then there is also reference to additional defined terms, supplier and facility. So we go up and we see supplier, paragraph 1. Supplier is Real Water of Tennessee, LLC. Right? We see that the place of business of Real Water of Tennessee, LLC, the supplier, is in Tennessee. And facility is located at paragraph 1, capital A2, that place of business. So we then turn to the bankruptcy order, the substantive consolidation.
Right.
And the court got it right. It was a substantive consolidation. I won't get into the details. We disagree that it's an efficacious document, but set that aside. Non-pro-tunc, backwards to August 21, 2021. So that's the date.
And that's what I wanted to clarify.
Right. And I just want to, our position is the court got it right. But all of the water that was produced and consumed well years before that date. So it doesn't matter really for purposes of this motion whether or not the 3 debtor entities, the 3 real water entities, were consolidated by virtue of the substantive consolidation. So when we look back to the indemnification provision, it says that Tennessee will indemnify UNFI. Well, even if the court were to expand that because of the bankruptcy consolidation order, it wouldn't have any effect on the court's ruling. Bottom line is, it's crystal clear that the plaintiffs have not alleged and will not allege that any product of Tennessee caused any of the injuries, specifically to Belsky and Haley, that are the ones that pertain to UNFI and the moving party. Your Honor, for those reasons, I think the court has a sound legal basis to grant this motion. There's no tribal fact that I just mentioned. Thank you.
May I, Your Honor?
Yes, you can.
Thank you. On the supplier agreement, paragraph 13A. Now, this is Exhibit A to
No, I have it right here in front of
Mr. Cavanaugh's motion.
me. And that's the indemnification insurance?
Yes, sir. And there are 2 separate obligations there, Your Honor. Schumacher, thank you. Mr. Schumacher just detailed the defense by the supplier. That is 1. That's in paragraph B, 13B. So, Your Honor, if we're sued, as we have been here, Real Water Tennessee owes us a defense. They should step in and pay for our defense. That's what 13B says. That's why it's key to the allegations of the plaintiff. Separate and apart from 13B is the obligation under 13A to indemnify us. This is a third-party claim seeking indemnification or contribution. Under 13A, Real Water of Tennessee has an independent obligation to indemnify us for any breach of this agreement. And a breach of this agreement, Your Honor, includes the provision of adulterated or recalled products. The product was recalled. That triggers the indemnity duty. That's all there is to it. There absolutely is a legal obligation under the contract. That's why Real Water of Tennessee owes us the express indemnity we're seeking. Now, as to a couple of the other arguments, Mr. Jones admitted in the 341 to the trustee that Real Water Inc. was paying Real Water of Tennessee's obligations. He did that on page 10 of the 341 transcript. He did it again in his deposition. He admitted in his deposition that Real Water Tennessee was operated out of Las Vegas by Real Water of Inc. without the provision of any consideration or agreements. That's at pages 123 to 127. The bankruptcy court order, Your Honor, absolutely does have force and effect, as the court suspected. The date, Your Honor, of 8/19/21 is the date that the consolidation took effect, but it's nuc pro tunc. It goes backwards from there. And that's the only thing that makes sense because it's based on what Mr. Jones did prior to that. It's based on the entanglement that the court found and the trustee alleged between and among the consolidated debtors.
Here's my question, and just a couple of things. Number one, is there a express indemnity third-party complaint filed?
Yes, Your Honor.
Okay, the only reason I brought that up because is there equitable indemnity also?
Yes, there is, Your Honor.
Okay, well, you can't have both, right? Either you have a contract or you don't.
The court's correct, and as you know, we're allowed to plead in the alternative. I think the express indemnity applies. I always prefer belts and suspenders to the extent the court were to disagree with the 13A express indemnity analysis. I'd have a fallback, in which case the implied indemnity, I think, would apply.
Here's my next question, and there's no question about this. There is an indemnification agreement, but then if I can find it again, but when I looked at the order regarding consolidation, it appeared to me that and I'm talking about the bankruptcy order.
Yes, sir.
And it didn't say, for example, and this is, I guess, page 3, paragraph 3 at line 3. It said the consolidated debtors and their estate shall be substantively consolidated non-pro-tunc as of August 19th, 2021.
Yes, sir.
So when I read that, it seems to me the consolidation time period would be August 19th of 2021. The torts in this case and potential deliveries and all those things occurred in 2019, right? In 18.
And let me address one thing Mr. Cavanaugh is absolutely correct about. Mr. Belsky's water from 2018 is not at issue here. It's only Mr. Haley's, which would have been produced after the March 1, 2019 date. But to the court's question, the August 19th, 2021 date is not the start date, Your Honor, from which the consolidation occurs, because as of then, the debtors can't take on new assets or liabilities. That's what the nuc pro tunc language means. It's reaching back in time. And the trustee briefed this at some length in seeking the motion. It's a retroactive determination that because of the prior actions of the consolidated debtors and because of the entanglement bred by those actions, that the consolidation looks back in time.
Does it have a what I would call an effective date of the consolidation?
Your Honor, I think
see where I'm going on that?
Yeah, I do, Your Honor, and I think the argument is that it's reaches back to the beginning of time. I don't need to.
I understand.
I don't need to articulate that because we have a very clear start date at which the commingling and the failure to observe the corporate formalities began on March 1st, 2019, which covers the production of Mr. Haley's water. And that's what the subject of the motion is, Your Honor, or the subject of the third-party complaint is, Your Honor. And given the vehemence of the arguments and the number of documents that have been consulted and the questionable, I don't think it's questionable, the effect of the bankruptcy order, I think it's obvious, Your Honor, that there is an issue of material fact here. Mr. Jones admitted that he paid out of one debtor's pocket the obligations of all debtors. Mr. Jones admitted that the operations of all debtors were run from one facility with no leases, no agreements, no rent paid. That creates, Your Honor, an issue of material fact. I'll close with this. I think the court's well aware of the facts here, Your Honor. And I don't think there's any doubt about the transfer of assets to the extent the court's question about that is something Mr. Jones listed on his bankruptcy schedule and under the penalty of perjury and testified to at page 160 of his deposition. It says here that you transferred all assets to Real Water Incorporated for $0. Is that correct? That's what the schedule says, is his answer. Yeah. So I don't think there's any, that fact alone creates the genuine issue.
When was the date of the transfer?
Your Honor, I have to pull up the schedule. Let's see if it's listed here in the deposition.
There are two transcripts, Your Honor. One is dated October 12, 2021. One is dated September 2021. The second session is Exhibit K to our reply brief, wherein Mr. Jones discusses the operation is out of Tennessee on page 17, lines 15 to 21, to counsel for UNFI's questions. That's page 17 on part 2 of the 341 testimony on October 12, 2021. Page 17, lines 15 to 21.
No, I'm sorry. I thought the court's question was, what was the date of the transfer?
Yeah.
And I'm sorry, Your Honor, I don't know that I have that handy. I can provide it to the court. It's referenced not only in Mr. Jones' deposition and in the bankruptcy schedule, but in the trustee's motion, where he says, per Real Water of Tennessee's schedules, it previously signed its remaining assets over to Real Water, which is further indication of the entanglement, warranting subsequent consolidation. Do you agree that Tennessee did assign its remaining assets to Real Water, Inc.? Yes. It's clear as day in the sworn deposition testimony and the bankruptcy statement. And the court's initial inclination is right. You can't run to bankruptcy court and throw your company into it to protect yourself and then try to run away from the representations you make there. This is Mr. Jones. This is his sworn testimony in the form of bankruptcy schedules and 341s. For better or worse, Your Honor, the consequences of that are consequences he's got to live with. There was one more piece of testimony, Your Honor, I wanted to call to the court's attention, and I'll sit down. I think the court understands the issue well. Here it is. Don, could you pull up, please, Mr. Jones' deposition testimony at 147, lines 15 to 21. Did you consider the Real Water entity, did you consider it to be a single economic unit? And one way, Your Honor, to evaluate the damaging nature of the testimony is to look at the number of objections here. Objection, objection, objection. The question was, did you consider it? And the objection is misstates the testimony. When Mr. Jones is finally allowed to answer, he says, I would consider that. After we bought them out, we were in the process of consolidating. That's exactly what he did, Your Honor. That's why there aren't separate documents and separate payments and separate. UNFI did a great job of tracking the different vendors. Real Water of Tennessee was run as Real Water Inc. That's why they were consolidated. That's why there's liability here, and that's why the court has to deny the motion for something.
Here's my next question, and I'm coming back to the bankruptcy court order.
Yes, sir.
And it says, I'm on page 2, and I don't know if this gives clarity or not, but it said the motion sought in order to substantively consolidate the bankruptcy cases filed by Affinity Lifestyles, Inc., gives a case number, and Real Water, Inc., and Real Water of Tennessee, and another case number. Non-proton to August 19th, 2021. And then there's a footnote. And then at the bottom of the footnote, it says here, all defined terms in this order shall have the same meaning as ascribed to them in the motion unless otherwise provided. What did the motion say?
About what, Your Honor?
About the effective date or the non-proton to August 19th, 2021.
Your Honor, if I may, the order that the court is referencing is dated December 2021. The
I
nunc
understand.
pro tunc is as of August 19, 2021. This notion that it's nunc pro tunc back to Genesis is inconsistent with the record in the bankruptcy court. And to the extent, I mean, this is a legal determination the court needs to make as part of its adjudication of the motion, I think. But the language in the statute, which the court is obligated to interpret the plain meaning, is clear. It's as of August 19, 2021. It's not backwards in time to a date unspecified therein. So clearly, anything that happened before that was not consolidated. The three entities were operating separately. And for that
And
reason...
I'm not saying I'm rejecting that, but what
Well, I
I'm
know.
saying is, just from a clarity perspective.
Well, it is clear to us, Your Honor.
No. I'm saying because, interestingly, if you look at it, when was the footnote entered into the order? Footnote 1 was right after that statement. And so, and this is what the order provides. It says all defined terms in this order shall have the same meaning ascribed to them in the motion unless otherwise provided. And all I'm saying is this, from a clarity perspective, is there something in the motion that was filed in bankruptcy court that might, but I understand your position.
None of the defined terms in the motion relate to the date, Your Honor, if that's where the court's going.
I think
The word entanglement was not, I word searched it, I didn't find it in the motion by the trustee.
Your Honor,
That's Mr. Neale's word.
it's absolutely in the declaration of the trustee supporting the motion. I'll look forward to the motion as well. I believe it's there. But here's page 6 of the motion, which says it tends to establish the debtor's affairs are entangled to such a degree. It talks about tends to suggest the debtors were entangled to such an extent. So in this paragraph, Your Honor, the word entangled, further indication of entanglement warranting substantive consolidation. I think the word search has failed. There's 3 in that paragraph. Nut pro tunc is described, Your Honor, on page 7 of the motion. The motion is at your Exhibit J to our opposition. And what the trustee explains is exactly what my understanding of nut pro tunc means. It means going back in time to recognize the factual reality that was present then.
Your Honor, so the record's clear as to our position. The nunc pro tunc is from the date of the order back to the August date. That's our position. We understand that UNFI takes a different interpretation. One last point, Your Honor. I think I heard Mr. Neale say, correct me if I'm wrong, sir, that he's not disputing the fact that the Belsky water predated any of the dates at issue here. And to me, that sounds like a concession, that there's no indemnity obligation arising, at least under the foods, the paragraph 13 of the agreement.
For Mr. Belsky, that's correct.
Okay.
As opposed to Mr. Haley, who's after that. So, Your Honor, nut pro tunc relief is appropriate because it serves to acknowledge what has already occurred. The 3 debtors' entities are hopelessly linked and entangled. There's the 4th iteration in 2 paragraphs. Such that they are and always were effectively a single actor. In substantively consolidating these cases, the court is not radically altering the makeup or relationship of these entities. It is simply acknowledging the reality of the debtor's interconnectedness. Because nut pro tunc relief in this case does not create facts that never occurred, it falls within the standards set by the Acevedo case. So it's, again, that's why it can't be the August 19th, 2021 date, because it refers to pre-declaration acts of the debtors. It refers to that entanglement Mr. Jones repeatedly admitted to under oath and wrote about on his schedules. If absolutely nothing else, Your Honor, that is a genuine issue of material fact, and the motion should be denied.
And gentlemen, you get the last word.
Well, Your Honor, just that counsel has conceded that at least as to Belsky, the motion should be granted. Correct me again if I'm wrong. Also, we feel that because of the language in 13B, where it says alleging any of the following related.
When you say 13B, you're talking about the indemnity agreement?
I am, Your Honor, and it's clear that the plaintiffs are not alleging that any of the water relating to Haley and Belsky came from Tennessee. Therefore, the indemnity obligation is not triggered. And the court should grant the motion. They still have the equitable indemnity.
Yeah, but I mean, they're just seeking relief for the consumption of real water. And here's my point: I don't know necessarily if the plaintiff determines ultimately what the equitable and/or express indemnity or contribution obligation shall be, right?
So what the court said, I didn't.
No. What I'm saying is, I mean, I don't think the plaintiff's complaint controls specifically, ultimately, what the equitable, express, and/or contribution claims will be down the road. That's all I'm saying. And I don't mind saying this too. In a general sense, I understand completely where you're coming from as far as the date's concerned. What I think we can do. Okay. This is what we'll do. Do you have a copy of the order? You get the last word.
Bankruptcy order.
No, I'm sorry, the motion. Have you read the motion?
Our motion.
No, the motion for substantive consolidation.
In the bankruptcy court, yes, but it's been a minute since I did that, Your Honor.
Okay. What you can do, we're going to take 10 and you can read it, and then I'll let you give your final word.
Okay.
So that it is the final word. May I say one thing, Your Honor?
Yes.
Todd versus Fort Defiance, 130 Nevada, 1245, quote, Nevada state courts have no power, respectfully, Your Honor, to review the findings of a federal bankruptcy court and must apply issue preclusion. Exactly what we have here.
Well, and here's the thing. I understand at the very outset I was very cautious of that, right? And I was. And I agree with that too. I'm just trying to figure out if it's clear or not what the bankruptcy court meant. And that I don't know. And just as important too, potentially you might have to go to bankruptcy court for that explanation.
And I think that's the subject of one of the follow-on motions after the court hopefully denies this.
One point, Your Honor, I apologize for being mistaken about the word entanglement. It was a similar word.
No, that's so. You don't have to apologize for anything.
Translation. I apologize. I didn't.
We're all
wrong,
working,
obviously.
Yeah. No, but we're all working very hard. There's a lot of complex issues here.
Sure.
And there's, this is one regarding indemnification expressed pursuant to the terms and conditions of the indemnification agreement. It's expressed. I understand that. Because remember, I don't mind saying this, and as a trial judge, you bring a lot to the bench based upon experience. And I will say this, and this is what I enjoyed about construction defect. I think when it comes to construction defect and third-party claims, there's no practice that deals with that in great detail other than construction defect, because half of the issues we had to deal with were third-party claims.
Right.
And as a result, you became, as a trial judge, I remember all the cases, Brown and explicit and the language. I mean, I remember all that. But my point is this, I recognize it. But just as important, too, as a trial judge, once again, this is my first rodeo, I've dealt with bankruptcy decisions made and what potential preclusive effect it might have in a district court. This one's not necessarily clear for me, but I want you to look at it just to make sure. And I understand one's out. We agree to that. And potentially, I mean, I don't know. I mean, I would stay away from bankruptcy court other than seeking relief from the automatic stay. I was pretty good at that. But you might have to petition the bankruptcy judge for clarity. I don't know, but we'll make a copy for you.
One point very quickly, Your Honor. As Mr. Rasmussen brought up, and I don't want to get him tangled up in this, but after the court issued a ruling on the motion to strike UNFW's answer, and the court issued its ruling, I also asked the court to distinguish between the repercussions of that for folks downstream who UNFW has an indemnity claim against, and fashion its order accordingly so that we don't suffer as a deterrent that we don't need to be deterred from on that particular issue. So.
Yeah, I think I know what I might do with this, but do you have a copy?
I'd like a copy, Your Honor, please.
Okay, we'll take a break, just make 2 copies of this so they can look at it, then I can make a decision. Just take 10 minutes. Thank you, man, I appreciate it.
And everybody's gone, Your Honor.
Or 5.
Yes, sir. All but 2. 2 of the ladies, all right.
We don't have to rise.
I apologize for the over-vehemence, Your Honor.
That's okay.
I'm just too disappointed. I should know better at this old age.
More time with that?
I'd like to see the actual order. I read the motion here.
Okay, we can get that for you. Wait a second.
Shall I get the other people, Your Honor? You want to leave this the way it is? Get things squared with him.
I mean, if the order is consistent with the trustee's conclusion, where he says non-trunk relief to the date August 19, I don't need to see the order.
Sorry, Your Honor. Sorry, Mr. Kemp. We're not.
Yeah, I didn't want to stop you from. I didn't want to stop you from talking, Mr. Kemp.
No, we were just trying to read, Your Honor.
Okay. We can go back on this. Yeah, we're back on the record. Is that correct, ma'am?
Yes, Your Honor.
Okay, sir, we've showed you a copy of the motion.
Yes, Your Honor, thank you. I'll just make a few final points consistent with the court's recent admonition. When looking at orders of the court, I think the court should first employ the plain meaning rule, and both in the order from the bankruptcy court on the motion from the bankruptcy trustee for a substantive consolidation. In the conclusion at page 8 of the motion, the trustee says, the trustee respectfully requests that the court enter into order A, granting the motion, this again, motion for substantive consolidation, in its entirety and substantively consolidate the debtor's bankruptcy cases, non-pro-tunc to August 19, 2021. The only way that can be read logically and reasonably is, since the motion is dated October 11, 2021, is that the trustee wants the relief to go backwards in time to August 19, 2021. Literally, that's what it says, and that's the interpretation that the Tennessee would urge the court to adopt for purposes of adjudicating the motion. One other thing, Your Honor, going back to the food product supplier agreement, which is Exhibit A of Tennessee's motion, there's another provision at page 5. It's 14I, and it's entitled Amendment. This agreement may not be amended, nor may compliance with any condition or covenant be waived, except by a writing executed by both parties, or in the case of a waiver of the party waiving compliance. The arguments advanced by Mr. Neale on behalf of the UNFI and the UNFW effectively asked the court to amend this agreement. Specifically, he is asking the court to issue an order that in effect would adopt an expansion of the indemnity obligation that we talked about previously in paragraph 13, because clearly the indemnity obligation in paragraph 13 is one owed only by Tennessee, not by the other two debtor entities. And that obligation, that indemnity obligation is only triggered when the plaintiffs allege a product produced by Tennessee caused physical injury to the plaintiffs. We don't have that. Mr. Neale is asking the court to interpret the bankruptcy order of substantive consolidation to effectively expand the definition of Tennessee within the context of this food product supplier agreement to mean all three entities, such that it does not matter where the water came from. That, Your Honor, would be inconsistent with the intent of the parties as expressed in paragraph 14I. And we urge the court to grant the motion as to both. I think the court has heard a concession as to Belsky. We also ask the court to grant the motion as to Haley for the reasons stated. This isn't the death knell for them. As counsel indicated, they do have stated cause of action for implied indemnity or equitable indemnity. Thank you, Your Honor.
All right. This is what I'm going to do. And I've reviewed both the order, and I've also reviewed the request for relief or the motion for substantive consolidation. And I'm going to just follow. I'm not going to interpret. I'm going to follow the plain language of the request for relief. And it says, quote, for the foregoing reasons, the trustee respectfully requests the court enter an order, A, granting a motion in its entirety, and subsequently consolidate debtors' bankruptcy cases non-pro-tunc to August 19th, 2021. And I looked at the dates, and interestingly, and I don't know why that date was selected, but the date of the order, it was electronically filed on October 11th, 2021, and same date it was signed. And so I'm going to grant the motion, however, and I'll just tell you this, if you want to seek relief from the bankruptcy court and ask him, is that correct, the plain language? And for example, I'll follow whatever they say.
Thank you, Your Honor. There's a petition pending there, and I think
For clarity, whatever they
Yes,
say, I will. For example, if they said, look, the consolidation goes back to 2019 and covers the date, that's their determination. I think I have to follow them.
I think, Your Honor, that we have some motions here that are perfectly harmonious with the court's rule.
Okay. But I mean, that's what it says there. And I looked at the order, I looked at the request, and it says 2. But Mr. Neale, you can, if the bankruptcy court makes a determination 2 weeks from now, it comes back in.
What I would ask then, Your Honor, I think we all understand the court's ruling, if we could stay the entry of an order or some such thing so that the judgment isn't in effect while the bankruptcy court looks at that issue, I'd appreciate it.
Your Honor, we would prefer the court do enter an order. We'll stipulate not to execute on it or whatever. There's no reason not to do it. If it's not entered, then arguably we need to sit here through the trial. Otherwise,
No, they don't.
So I don't think anybody's asking Tennessee to sit here, Your Honor. Mr. Kemp's next motion, and we agree with it, is that Tennessee can pack up and go home, and whatever equitable analysis there needs to be done after the verdict can be done.
Right. And, well, you know, as long as you prepare the order, it doesn't have to be entered. You'll hold it in abeyance, and once you get a determination on the question.
Your Honor,
question.
for clarity, our motion is granted in its entirety, correct? Both as to the express and there's no claim, no third party claims are made. Is that right?
Well, you just said my indemnity survived.
No.
Didn't you just say that from the vote?
No. Did I?
Yeah, you did.
Yeah.
Yeah, you did.
Well,
I'd like to non-vote revise my argument, Your Honor.
Talk about approbating and reprobating.
No, but seriously, I want to understand what the court's order is. Is it?
I was just following. I granted for both issues, and I accepted your representation that you're not going to. Didn't he say he wasn't going to file it?
I thought he said it didn't apply to his.
He absolutely said it didn't apply. They're not out of luck, or words to that effect.
You can give us clarity, sir. That's okay.
We would ask that the court grant the motion in its entirety so that would moot plaintiff's motion eliminating number 41, and we can address this in due course if and when there is a judgment against UNFI.
If the court enters a judgment, I can't come back to court and refile on an already dismissed claim. And so, to the extent it does anything, the court should either hold the order in abeyance or dismiss it without prejudice or some such thing, so that the petition that is pending in the bankruptcy court and that was filed a few hours before this motion was filed can be heard.
And what I'll do, I'll grant it without prejudice. And if any review of my order will be based upon whatever determination the bankruptcy court makes.
Thank you.
So without, I'm still.
I'll make it real clear for you. If the bankruptcy court says, look, and you can come back and they say the effective date would be of the non-pro-tunc order, as far as how far back it goes is August 19, 2021, you can come back in and request that I make it final with prejudice, so that triggers the appellate rights.
Okay, so it's without prejudice pending the bankruptcy's decision on the issue.
Right.
Period.
As to Haley.
As to Haley.
Right.
Belsky is gone.
Belsky's gone.
With prejudice.
What if they say no pro-tunc back to 3/1/19, Your Honor?
Pardon?
What if the bankruptcy court says no pro-tunc to 3/1/19?
3/1 of 19? There's another issue there.
Then I have an indemnity claim against Tennessee.
Wow.
All right. Okay. All right.
But the whole basis for it is this. I mean, I think I'm right, but I'm not 100% certain. I don't want to impact your client's rights, and potentially we can have a determination. Within 30 days, we can know what the bankruptcy court's saying.
I don't know that it'll be that quick, Your Honor.
Not this bankruptcy court, Your Honor.
But conceptually, this is exactly the solution that Mr. Kemp and I separately proposed.
Okay, well, I guess that puts me on the same. That puts me on the same page with you guys, right?
You're in good company.
Your Honor, here's the rub. So I'm confident that plaintiffs are going to present the claims that I quoted into the record, but I'm equally confident that Mr. Neale, in the defense of his client, is going to try and shift the blame, so to speak, no aspersion intended, to Real Water, Tennessee. The ship is going to sail on that. We're not going to be participating in the trial. So I'm a little ambivalent on what to do here, because I'd rather be part of the fate of my client opposed to sitting in my office shuffling paper. So
this is why we propose that all these equitable indemnity issues and what have you be decided after you do the compensatory and punitive, some sort of third phase.
Well, typically when it comes to all the indemnity and contribution or whatever claims, they're typically not ripe for adjudication until there's a verdict entered in the case.
That's
right. I mean, they typically aren't. So I don't think, and in a general sense, I mean, and at that point, say hypothetically, they said there's an effective date, and she says it is what it is, and maybe it covers this claim, he or she, whoever the bankruptcy judge is, then at that point, what I would do is I would do like we always do under the Brown case. I would take a look at the language that's set forth in the express and in the agreement and make a determination as to whether or not this specific loss is covered.
Understood, Your Honor.
Isn't that how we did it, Mr. Cavanaugh, all the time? You know that.
Well, that's the CD way.
That's the CD world. And why is it any different? Because this is third-party practice, and I will say this: the CD lawyers, I guess, it's probably not true today, but at that time when it was really moving significantly, they really practiced at a high level as far as third-party practice is concerned. Right, Mr. Rasmussen?
We'll agree with you, Your Court.
Yes.
I've been there, and I've been in phase 2 of these trials.
Many times.
Hate to say it.
Yes.
Judge, so that would, as I understand it, make the motion to eliminate 1, 2, and 3 of Real Water Tennessee moot.
And your motion to eliminate 41, I would agree.
Okay.
Because understand this, I mean, I just want to make sure I'm really clear. It seems like this is for example, and I realize it might take a little time with the bankruptcy court to get the final determination as far as what the judge meant as far as interpretation of the motion and the in the order. But at the end of the day, when it comes to the express indemnity rights, either they're covered contractually or they're not.
Your Honor,
Right?
Yes.
I agree.
Yes.
Want to clarify
Okay.
Mr. Kemp's comment about Tennessee's motions limiting 1, 2, and 3 being moot. 2 is really not moot. 2 is to preclude UNFW from referring to the bankruptcy consolidation order. Number 1, I think we've excluded the ability to refer to the bank. Are you going to,
Matt? Judge, I'm not going to bore the jury with the bankruptcy order if Mr. Cavanaugh's not here.
I think
Because, I mean, realistically, what I could do, I mean, and I don't want to do this hypothetically. I don't want to force you to sit here through a trial unnecessarily. I've interpreted it. I'm trying to do it the best way I can. Right?
We like your interpretation.
Yeah, exactly. But my point is this. Typically, Mr. Rasmussen, like you said, you've sat through many a phase 2 as it pertains to contribution claims and or indemnity claims. And many times that can be handled potentially by law and motion. Sometimes you have to take evidence or whatever.
Sometimes we just go settle it.
Yeah, exactly.
Well, but there were other times where our dear friend Bruno Wolfson would lay down and hammer on the subcontractors. So phase 2, we'd have a fait accompli.
I understand.
If Mr. Kavanaugh suggesting 2 be granted, I would not oppose that because I think that's already covered by our motion.
Your Honor, 2 is not contested. We're not going to enter.
Not going to phase 2 and phase 1
against an absent party.
Yeah, that's just not good. It's not good form.
To argue a legal issue to the jury.
so
Because at the end of it, I don't mind telling you this because what's going to happen, one of 2 things. Either I read it correctly and interpreted it correctly, or I didn't. Yeah, or maybe the bankruptcy judge looks at it slightly different and says, I don't know if I meant that. This is what I really meant.
Then that's the decision, isn't it?
It is. And then what am I going to do? I'm going to follow whatever the bankruptcy says. Exactly.
Thank you, Your Honor.
Thank
You
you.
have clarity on that. Does that help?
Yeah, all right. I think it's clear enough so we can leave, right?
Yeah.
Okay.
I'm surprised you want to leave.
I'm not surprised when I just up and out the door already.
I'm going to stay. He may leave right now.
But you're coming back. We gotta talk.
Yeah, Judge, the way I construed 12 is there's no reference to the bankruptcy in 13 phase anyway.
Anyway.
Yeah.
Period.
That's already been ruled on, right?
Yeah, that's already been ruled.
Right. If you excuse, I may be coming right back.
Sir, if you need to leave, you can leave. If you need to come back, you can come back.
Thank you, Art.
Gentlemen, before you leave, so there is this exhibits.
Oh, good question.
No, okay.
What?
That is true.
What happens to your exhibits?
Anybody want to buy them? No takers, huh? Well, that isn't it. Can we have a day to figure that out, Your Honor? Because we're going to go try and distill what happened and figure out
Tomorrow
what
morning.
is.
Tomorrow morning.
Judge, what I would suggest is that since they're not going to be involved in the first phase or the second phase, that they be given some later date to file their exhibits.
That's agreeable.
Who knows what's going to happen in the third phase? Who knows?
Right.
Who knows if there's still a UNF claim? I don't know.
So,
Yeah.
Sounds fair.
so Maria, I'm going to issue a request for the transcript.
So what are we going to do with the exhibits? That's what you're going to ask, right?
We're going to let you know tomorrow,
Should
Your
we-
Honor. Let you know tomorrow.
That's fine.
Thank you.
Yeah.
I'll get it.
Granted.
granted, I think it's moot, but granted's fine. with me.
It's uncontested. The court should feel free to grant it if that's your inclination.
It's uncontested, I grant.